Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and we're going to have a webinar today with this very special guest joining us again. And yes, it's going to be a kind of a new topic altogether, but it's going to be a good one. So I hope that you're very excited to get to know more about the I-485 application in depth. I was telling you we are going to be joined by this very special guest. So please help me welcome Mr. Prashant Rajendra Dubey. Yes, attorney Dubey again. This is esteemed attorney, who offers legal services in business and tax and immigration law matters with 5 years of experience in immigration law and yes, friends, notably in 2023, Attorney Dubey's firm, Dubey Law Office, PLLC, was also recognized as the top 10 immigration law firm by Silicon India. And it's truly an honor to have you with us today, Attorney Prashant Dubey. Thank you for joining us once again.
Yes, thank you, Nipasa, and thank you to the Higher IT team for hosting me again as a part of the series of webinars that we've been doing. I also want to thank Zayed in the background, right? He's kind of making all of this all of this work and coaching us through any technical issues. So thank you, Zayed. But also thank you to the wider team again for hosting me today. We had I think five webinars previously as it related to the I-140 process, right? Starting with the prevailing wage determination, then going to the PERM, and then discussing the I-140. I'm not going to go into those topics at length here, but just so everyone understands, the I-140 process is just a verification from USCIS that the job that you've been sponsored for meets all of the requirements of an EB2 versus an EB3 employment-based visa petition, right? And you get your priority date from your PERM filing. And so when it comes to the 485 application, that is actually the very last step in an employment-based green card process, where once your priority date is in fact current, you can then apply for the 485 application, which is going to get you your physical green card in hand. And we can go through that discussion during today's webinar.
Absolutely, absolutely. And it's going to be a good topic today. We are going to discuss, about demystifying the I-148 I-485 application and in-depth guide to the introduction, the process and complications and pro tips. So it's a very, very vast topic. Let's see how much we can cover today. But definitely, friends, wherever you're watching us from, whether it's Facebook, LinkedIn, or YouTube, if you have any questions to the attorney directly regarding this topic, you can definitely put in your questions in the comments and we'll be very happy to answer later. And thank you so much for joining us, everyone. So, without further ado, also, before starting with the questions, I wanted to say, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. And Attorney Prashant Dubey, let's go ahead with the questions I have, for you today. And this first one, directly, is if you can provide an overview of what the I-485 application is and its significance in the immigration process, what we're going to talk about today.
Yeah.
I think you're muted. There is some, I cannot hear you. I think there's some problem with the audio.
1 second.
There, I can hear you now.
Okay, just 1 moment. For whatever reason, it's disconnected from my from my AirPods. So give me just a second. This has happened
That's all right.
another time on one of these episodes. Let me just connect
Yes,
it.
I remember, but it's all right. It happens.
Yep, absolutely.
Technology.
Okay, can you hear me?
Yes, we can.
Okay, wonderful. And I've got you back in my ears. So thank you for your patience, and thank you to everybody watching for your patience. Um, as I was saying, as a quick recap, right, it's important to understand the 45 application, or as it's named, the adjustment of status application is really the last step in an employment-based immigration procedure, right, in order to get your physical green card. So this application allows you to actually apply for a green card from within the United States. And as we were talking about in earlier episodes, this process doesn't just start with the 485. It starts with the prevailing wage determination and the PERM, which is a procedure you do with the Department of Labor. Then it goes to an I-140 application filing, which is something you do with USCIS. And for individuals that have a priority date that is, current as of the date of their filing the I-140 application, which is basically individuals that are not from China or India, you actually have the privilege and the ability to apply for your 45 application concurrently with your I-140. Now, if you are a national of China or India, there are often long, long waiting times, right, to apply for the 45 application. And that's because there's a very big backlog associated with the priority dates, which is currently hovering around the 2011, 2012 range. So this step, it's extremely significant, right? Because it's what actually allows you to get the physical green card in hand. And you can only apply for it when your priority date is in fact current. And so in in 2020, one of the things that we saw was there was this great progression of priority dates, especially for folks from India and China, because there were some spillover happening from other visa categories due to embassies being shut down worldwide, green cards not being issued through those embassies, that sort of thing. And so a lot of individuals, their priority dates progressed up until 2014, 2015 in some instances, and they were able to apply for their 485 application, right? So these were individuals that for several years already had an I-140 application approved, but because they're a national of China or India, which also happens to be, I would say, probably 90% of my client base, they had to end up waiting to apply for the 45 application until their priority date became current. And so these individuals were able to then get their 485 applications submitted, right? So it's very significant that the 485 application be submitted as soon as your priority date is current, or if it's already current, so that you can actually get that green card in hand. Another thing to keep in mind for the 485 application is that it also has this thing called a 485 Supplement J. The Supplement J is filled out by the employer, and it's basically an affirmation by the employer that they're willing to sponsor you for the job or that they're willing to employ you for the job that you were originally sponsored for, right? Along with that, we also send a 765 application for employment authorization and a 131 application, which is an application for advanced parole, and it allows people to travel. So that kind of summarizes the significance and kind of a high level overview of the 45 application, as it does allow you to finally get that physical green card in hand.
Absolutely. And we are going to thoroughly talk about this topic today and so many things in it. In fact, we have folks in YouTube asking questions already, I can see. And Mahaboob Basha says informative and gives a thumbs up. So thank you so much for joining us. And also, Angie is asking. But then, Angie, this question, we are definitely going to touch on it later. And she asks about some complications and challenges. So we are definitely going to get into it. But for now, I wanted to ask, what are the key eligibility criteria for filing the I-485 application so that people know if they can apply for it?
Yeah, and I want to make sure we've got a distinction here between like the family-based petition, right? There is a probably separate webinar we could do around just family-based 485 applications, right? In order to
Right.
continue our series around the employment-based petition, we're going to keep on that talk track. So keeping family-based 485 applications or asylum-based 485 applications aside and sticking just to employment-based 485 application filings, there's several criteria. One of which I have alluded to a couple different times, which is your priority date needs to be current, right? So number one thing, in order to get a 485 application submitted in the EB1, EB2, EB3 categories, is that your priority date must be current as per the date of filing chart or the final action date chart. So to add another layer of complexity, USCIS and the State Department have created two separate charts, date of filing and final action date. Oftentimes, they will leverage the date of filing chart, which moves a little bit faster than the final action date chart. And they will inform the public that, in the month of February 2024, we are going to allow people to use the date of filing chart to file their 485 applications. So if your priority date is current, as per the date of filing chart, and USCIS is leveraging that chart for purposes of 485 filings that month, you can go ahead and submit your 485 application. Now, you won't actually get your green card until your final action date, your priority date as per the final action date chart is current, right? So something to keep in mind there with regards to the priority date. So number one, your priority date must be current. Number two, you should have entered the US legally and maintained legal status, right? So it doesn't necessarily matter, whether you have an expired, let's say, non-immigrant visa, but legal entry means you were actually inspected by, CBP and admitted into the US or paroled into the US. For purposes of the 485 application, you also need to be physically present in the US. There's a completely separate process called consular processing for those that are outside the US. But in order to file a 485 applications, you must be within the US. You also have to be able to demonstrate that an employer is willing to employ you once you get your green card, right? So that whole process you did with your employer when it came to the prevailing wage determination, the PERM filing, the I-140 application filing, you need the support of your employer for that supplement J that's part of the 485 application for them to be able to sign off and say, yes, a job is still available to this individual. I plan to employ them after they get their green card, right? That's your way of basically telling USCIS, hey, I'm going to be financially sound after I get my green card. And I'm not going to become a liability to the US government. They're also going to collect some information around potentially fraudulent or criminal activities, right? Have you been in any criminal proceedings? Have you committed any sort of fraud? Have you ever misrepresented yourself in front of the government or to USCIS specifically? And then the other eligibility criteria is that you have to provide evidence of a medical examination. So one application I didn't mention is the I-693 application. And that is basically, have you gotten all your vaccinations? Are you going to be some kind of a medical threat potentially to populations within the US? So from a high level, those are about the 6 or 7 criteria that you want to be mindful of when it comes to the 485 application.
All right. So, folks, I hope that you will have at least your records clear so that you can go through the whole process of filing it even. So, if you think you are eligible and you're probably already under the process, I hope some of your doubts are cleared at least. And if you could actually, Tony, walk us through the general process of filing the I-485 application from start to finish. Like, of course, if I'm eligible, I go apply for it. So what do I have to do in the beginning and how do I go through the whole process till the end?
Yeah. I can speak to our firm's process, right? When it comes to, how we file 485 applications, right? So typically what'll happen is a client's going to approach me and they'll say, hey, I have this I-140 application, that I filed with my employer, and my priority date is current. So I typically get on a 15, 30-minute call with them to understand when was your I-140 filed? What's your priority date? Are you still with the same employer that sponsored your I-140 application, right? Now, that's very important because sometimes what will happen is, and I saw this happen in 2020 specifically, that people will leave their sponsoring employer and their new employer doesn't have an I-140 on file for them or is in the process of doing it. And let's say your priority date becomes current during that time, unless your previous employer is willing to hire you back and fill out that supplement J for you, you can't file a 485 application, right? So understanding who you're employed with when your priority date is in fact current is a very critical part of that call and part of the process. So once we've established those details, I typically send them a checklist of documents for themselves and their dependents if they have dependents, right? And the documents that we're looking at and that we're collecting is, the I-140 approval notice, any 797A notice of approvals that you've gotten while you're on H-1B or L-1 status, for example, since you've been in the U.S. Copies of passports, I-94 records, birth certificates, the 485 supplement J, which needs to be filled out by the employer. We need passport style photographs for the applications. We need a marriage certificate, criminal records if that's relevant to a person's situation. And once I have those documents, I send them a questionnaire for purposes of the application. It collects information like your address history, your employment history, your foreign address. When was your last date of entry into the U.S.? Basically, details in the I-94 record, along with a whole bunch of just biographical information, right? When were you born? Have you used any other names? Did you, what were your parents' names? All of these pieces of information and details are collected in the 485 process. And so once the questionnaire is complete, I then finalize the application package, which includes the 485, the 761, the 131, the 693 medicals, and we prepare everything for filing at that point, right? And in parallel, at some point in that process, I collect fees. So USCIS fees, for example, are $1,225 per applicant. And once the application is in fact submitted, what happens is USCIS will first cash the check. To me, that's very important because once I know that they've cashed the check, it means they've accepted the application. It means that the application has not been rejected. It's not going to bounce back to me because a signature was missing, or we incorrectly, we provided the incorrect amount on the USCIS fees. And from there, what will happen about a week or two later, we will get USCIS receipt notices. And then the step after that is USCIS will often issue what's called a biometrics appointment notice, right? Which is basically they're going to invite you to come to a local application service center. They're going to take your fingerprints and they're going to run those fingerprints against the FBI database, and they're going to do their own criminal background check on you, right? And really, once that happens, once the biometrics are completed, oftentimes, my clients, for my clients, it's just a waiting game, right? You're just waiting for the approval to come back. And in very rare circumstances, USCIS might issue a request for an interview, right? Where they will tell you, hey, we maybe see that a previous employer that you're no longer working with, they're the ones that have filed your supplement J. We want to come learn, more about that. Come into our offices. Tell us about how you're going to be working for this employer. If, for example, you're in a completely different city, right? That employer might be in DC and you're living in Florida. How's that going to work, right? Is this a remote job? Are you planning to leave your current employer and move back to your former employer? So those are scenarios where oftentimes I will see an interview be issued. So end to end, that is the 485 application process. And sometimes some people can have an interview with a USCIS officer tacked onto it.
Right. And I hope that folks out there are very much prepared for all of this because they need all their documents right. They need to be very transparent about every detail, spellings to everything. I mean, so
Yeah.
I hope and no mistakes can be accepted ever, right, Tony?
Yeah, I mean, it's not necessarily about mistakes. Yeah, you want to make sure you're working with an attorney, and again, it doesn't have to be me. You want to make sure you're working with an attorney that can at least um, have a second set of eyes, or at least just be your first set of eyes, right? And I've seen a multitude of clients where they'll prepare the applications themselves, and then they'll say, hey, can you just review this for me, right? And then file it
Mhm.
and be my G28 attorney on record. And I say, sure, right? So I can be your second set of eyes, or someone can be your first set of eyes and do the preparation end to end for you. And you're right, misspelling and certain mistakes can delay the process, right? Like if you just spell your name wrong and they run a criminal background check on you, and you have a clean a clean criminal record yourself, but somebody else with that misspelled name has a criminal history, they're going to come asking you why, right? They might issue an RFE, things like that. So if you're not careful about the things you're putting in the application, it can at the very least delay your process. I haven't seen something as egregious as a mistake that would lead to a denial, but it will potentially delay it.
Right. Talking about mistakes, I actually wanted to ask, what are some common mistakes applicants make when completing and submitting the I-485 application?
Yeah. So the most common mistake I see, and it's not like something that leads to denial, but the most common mistake I see is that individuals will wait to submit their I-693 medicals. So instead of submitting it along with the 485 application, which is often what I recommend that people do, they'll wait for USCIS to issue what's called a request for evidence, right? An RFE. And once the RFE comes in, then they submit it. But now you've just added another potential 2, 4, 6 weeks to your application process when you could have just done it on the front end and got it over with, right? And I always leave it up to my clients. I tell them, like, hey, look, we can work speedily, right? Like I can get your 45 application filed probably in about 3 to 5 days. But if we maybe take another week, maybe 2 weeks, and you get the medicals done, then you'll probably be saving yourself a little bit of time along the way, right? Because USCIS is going to come asking for those medicals. Another issue that I've sometimes seen is that people will try to submit the passport style photographs by having taken it themselves, right? So sometimes what will happen is these don't fit USCIS standards, right? And so what I always recommend is when it comes to those passport style photographs, just go to your local CVS, go to your local Walgreens, wherever it is, spend the 15, 20, $30 to get it done, correctly, so that again, you're not dealing with an RFE situation, or a situation where I've seen a client that USCIS issued him a letter and said, we want you to come to an application service center just so we can take your photographs. And I'm thinking, wow, what a waste of time, right? Another mistake I've seen is where sometimes people don't have a birth certificate and they need to obtain either a non-availability of birth certificate or provide secondary evidence, right? And these can be affidavits, school leaving certificates, which can act as your secondary evidence. So I always say have those things prepared so that when it comes to filing the 485, once your priority date is current, you're not scrambling around to get an NABC, and those are not easy to get. You have to get that from your home country. And for my clients from India, oftentimes it involves bribing people just so they can get it back quickly, as opposed to going through the normal government processes, which can take months, right? So keep those things, in mind, prior to even starting this process. So those are some of the common mistakes I see. I would say another common mistake I see is withholding information around, any criminal records, right? People will say like, oh, I got this parking ticket, or, I got this violation. Do I need to disclose that? And I always say, look, we want to be as transparent as possible to USCIS. So even if it is a parking ticket, I want to know about it, right? Don't withhold information that, at a later date, USCIS is going to come asking for anyways, because they've got access to an FBI database. They're going to see every single thing you've ever done, whether it's a parking ticket, or, some more egregious crimes, like theft, larceny, things like that, that have come across my desk. So just something to keep in mind. Always be honest, always be transparent with whoever you're working with, so that they can represent you in the best possible light.
Those are words of wisdom, friends, and you have to keep note of each of them while you are going through this process or even thinking of applying for this. So, actually, Prashant, we have a lot of folks out there watching us in YouTube and they have questions. So, I'm thinking since it's very relevant to what we just spoke, going to take up two of them and then maybe go for a break. So, this one is from Angie, and she says, what are some common complications or challenges applicants might encounter during the I-485 process? That we
Yeah,
covered
so
first.
I would say the biggest complication or challenge that I've sometimes seen, and there's two separate ones. One is around birth certificates, right? If, for example, the birth certificate doesn't have your name on it, or if there's a defect in your birth certificate, you need to obtain that non-availability of birth certificate from your local government authorities, right, from where you were born. Um, or you need to find a way to get secondary evidence, and these can be school leaving certificates. These can be um, affidavits from family members, right? Maybe you have siblings, cousins that know the circumstances of your birth. So I would say birth certificates sometimes always pose a challenge. If they're in your native language, make sure they're translated, right? Do get them translated. Um, I would say the other challenge I sometimes see, and this is a really big one, I feel like the one with the birth certificate can be very easily overcome, but the other one I sometimes see is, a different employer on your supplement J than the one you're working for, right? And this one gets very complicated very fast because, let's say employer A, who filed your I-140 petition, who helped you secure the priority date and all of those good things, they are in a physically different location, California, and you are with employer B and you live in Florida. But employer A is the one that's filled out your supplement J, saying, yes, I'm going to employ this individual after, he gets a green card. Well, USCIS is going to take a very close look at that, right? Because chances are you move to Florida for a better job, better pay, right? And you're definitely in a different different location. So they're going to ask you point blank, are you really going back to your old employer who's going to pay you less, right? There's really no good way to answer that question other than to be able to say, hey, yes, I actually, I've already secured a job offer with them. They're coming up a little bit on the pay. And I think obtaining my green card is much more important than me staying in Florida and working with employer B, right? So that there are ways that you can overcome it, but you just need to make sure you've got the paperwork to back it up, right? If you've never had a conversation with employer A since they submitted your supplement J, then it looks like all they did is on paper sponsor you, as opposed to actually be willing to bring you back once you get your green card, which is what USCIS is going to be looking for. So those are the two things that I typically see. And then another complication that can arise, as I mentioned a little bit before, was around criminal records, right? Don't withhold anything. Don't be ashamed of anything. Everything between you and your attorney is going to be confidential, as well as whatever gets sent to USCIS and whichever officer is taking a look at it. So always be sure, to disclose that information, however small or however big.
Absolutely. Thank you so much, Angie, for asking that. And I hope that many folks out there could get their answers to this one. And we'll take up another one. This one is from Anirudh. And he writes, we are about to submit our I-485 applications. I would like to know your thoughts on submitting the I-693 forms, the medical exam. Should we submit concurrently or after receiving the RFE?
Concurrently all the way, right? It'll add an additional 2 weeks to your process, but an RFE might add 4 to 6 weeks to your process, right? So if you think about it end to end, you're saving time by submitting it now, right? It'll probably take you a couple of days to secure an appointment. The civil surgeon, as they call them, the civil surgeon will probably take another week to prepare. In parallel, just have your 45 applications ready and prepared so that when your 693 medicals do come back, and they come back in a sealed envelope. So do not open that sealed envelope, right? The civil surgeon will obviously tell you the same. But if someone hasn't told you that, do not open the sealed envelope. Only USCIS can open it. So, at max, you're looking at a delay of a week and a half. Whereas if you get an RFE, USCIS is going to send you the RFE letter. It's going to reach you in a week. You're then going to go get the medicals done, which is going to take another week and a half, 2 weeks. You're then going to send the medical RFE response back to USCIS. They're going to take 2 weeks to process it, right? So you've just added 5 weeks, or maybe even 6 to your timeline. So I always say, if you can get it done on the front end.
Absolutely. Thank you so much, Anirudh, for that question. And we have many more questions. I also have some more questions about this topic, but we'll definitely go out for a break. And folks out there, wherever you're watching us from, Facebook, on YouTube, or on LinkedIn, if you like this information, this webinar so far, don't forget to hit the subscribe button, the like button, and stay in touch with us. And of course, if you have direct questions to Attorney Prashant Dubey, you can mail him at info@dubeylawoffice.com, and you can even mail me at nipa@higherITpeople.com, or WhatsApp me the number 408-335-6444, and definitely visit our website www.higheritpeople.com. And folks out there, don't go anywhere. We'll just go for a short break.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472, or mail us at support@higheritpeople.com, or visit our website www.higheritpeople.com.
Welcome back, friends, to Immigration and Jobs Talk Show. I'm Nipasa Pradhan, and today in this webinar, we have Attorney Prashant Dubey joining us from Dubey Law Offices, and we are discussing about demystifying the I-485 application. We are actually, giving an in-depth guide to the introduction, the process, some complications, and yes, Attorney Prashant Dubey is also going to give out some pro tips, so definitely stay with us. And Attorney, I hope that you are liking talking about this topic currently that's going on. Yes.
Yeah, absolutely. I mean, it's a topic that I'm passionate about for a few different reasons, right? Because I think for the employment-based process, that's one aspect to it, right? But the 45 touches, family-based processes as well, and to me, that's personal because I went through that process with my spouse. And for the employment-based process for my clients that I've seen them have to be very creative, from having to jump from EB2 or EB3 into EB1, or downgrade from EB2 to EB3, in order to make the priority dates work with the visa bulletin, and then really have their lives changed because they can now get a green card, right? And for individuals that are backlogged, like in India or China, they've been waiting in some instances 10, 15 years for that. I had a client who he actually didn't go back to India and see his family for 15 years, right? People are so concerned and scared of the US immigration processes that they're just like, I'm going to stay put until I get my green card, right? Or at least until I get it filed. And those, if you think about that, like, it's mind blowing, that that folks will do that. So it really is, I think, it changes a family's trajectory for generations, and that's why it's so important for them to be able to participate in it.
Definitely. And for so many people out there, it's a dream to become a US citizen. So definitely touching up on so many things today. And, about the current news, right? If you can actually shed some light of the recent USCIS, regarding the process time for Form I-485 when filed together with Form I-130, Form I-140, or Form I-360, what advice would you offer to applicants who are awaiting ad- adjudication of their concurrent filings? And are there any proactive steps that they can take, to expedite the process or ensure they are kept informed,
Yeah.
of updates?
So I would say, in terms of the USCIS answers, right? A few months ago, what happened was there was a Q&A with USCIS where people started asking them like, hey, back in 2020 to 2022, you guys collected a lot of 485 applications in the employment-based category. What's going on with the processing of that, right? Because you subsequently retrogressed all the priority dates. So we've got people who are in fact able to file the 485 application, secure the benefits of it, like getting work authorization through a pending 485 or getting their advanced parole document, but they don't have their physical green card in hand because the priority dates retrogress to like 2012. So individuals with priority dates in 2014 are feeling, well, now I'm waiting again. I was waiting after my I-140 application got approved. I'm now waiting even after filing a 45 application, right? Because there's only a limited number of these visas that get issued, or these green cards that get issued every year per country. And so what ended up happening, folks point blank asked USCIS, what are you guys thinking about the processing time? And I think, their response discouraged a lot of people, right? And what I mean by that is they basically said, we've already got enough applications from that 2020 to 2020 rush of 485 filings, that we can use up all of them, for countries like India and China, through the rest of this year, right? So when you're seeing priority dates now progress very, very, very slow. In fact, the start of their most recent fiscal year, October to December, I don't think there was any movement on the priority dates. They were just stagnant, right? We're seeing some movement now, but not a whole lot. But it's because USCIS is like, we've already got enough applications, right? We don't need to move priority dates forward anymore, nor can we, because of the backlog of 485 applications that are in our queue. So that became very discouraging for folks. And, unfortunately, there's not a whole lot anyone can do to expedite the 485 process, right? Because if your priority date isn't current and you're just waiting, then that's the situation you're in until your priority date becomes current, or unless you try to jump from EB2 to EB1, for example, which I've had about a dozen or so clients do in the last year, where the EB1 priority dates are moving much faster. So as a result, their priority dates become current again, and they're able to get the green card by filing in a new category. Other than that, there's not a whole lot you can do but wait for your priority date to become current. Now, for individuals where your priority date is already current, right? Maybe you're a national of Nepal, maybe you're a national of Pakistan, maybe you're a national of Canada or England, that sort of thing, where you don't have backlogs. I would say file your 485 application along with your I-140 application, right? Because again, your priority date is already current. You can concurrently file with the I-140. Don't wait for the I-140 to be approved, right? Because if you've already got the background and you feel confident about your I-140 application and you're not dealing with a priority date backlog, just file it all concurrently so you save yourself time. Again, even for those individuals, I don't think there's a whole lot they can do to expedite a 485 application, because there are things that USCIS needs to do on their end, which is, they need to run a proper background check. on the individual being sponsored for and their family, right? There's security checks that are involved when it comes to getting a green card. Now, with that being said, if you're facing like an unreasonable delay, right? Your priority date's current, your application's been pending for over a year, maybe over 14, 15 months, it's out of USCIS processing time, you can always try raising an expedite request. You can always try raising a service request. You can approach your local congressman or congresswoman and try to get it expedited that way. Now, if none of those work, you can come knocking on my door and we will go file a lawsuit against USCIS to extract your approval, right? So I have seen in the last 5 years, I've seen a handful of very wonky sort of cases, and I don't have a better word for it because, these are individuals where their priority dates were current, but their applications were pending 3 years, 5 years, 7 years. And they were like, Prashant, what's going on? And I'm like, I think you just slipped through the cracks, right? You've tried everything. You've tried an expedite request. You've tried a service request. You've tried reaching out to your senator. You've tried reaching out to your representative, and none of it's working. So what our firm is famous for is litigation, right? We've done over 500 lawsuits against USCIS. And some of those have been for 45 delays, right? So, we can file the lawsuit either where you live or the jurisdiction in which the application is pending. Maybe it's Texas, Nebraska, Vermont, California, whichever service center it is, and we can extract the approval that way. Because waiting 3 years, 5 years, 7 years, or waiting, when you're outside of your processing time and your priority date is current, that's unreasonable, right? You've done all this hard work only to be let down by USCIS because they're not approving your applications, right? So that's typically where another lever we can pull to expedite it if you're out of processing time. Another thing that I would note is just make an exhaustive application package. We've alluded to it multiple times. File the 693 application along with your 485. Make sure your passport style photographs are proper and pass the USCIS litmus test, just so you can avoid any sort of RFEs later down the road. That is in a way in and of itself that will intrinsically expedite your process because you will avoid an RFE type of situation.
Right. And if you can actually explain, the role of supporting documents in the I-485 application process, and even if you could offer some tips for gathering and organizing them effectively.
Yeah. So supporting documents are important, right? Because they essentially help USCIS establish your eligibility for a green card, right? They tell a USCIS officer about whether or not you qualify for it, right? And this will involve collecting several documents, such as the I-140 approval notice, 797A notice of approvals you've gotten from within the country, copies of your passport, copies of your visa stamps, I-94 record, birth certificate translation. If you don't have a birth certificate, then an NABC or secondary evidence, right? You're going to need the supplement J, criminal records if that's relevant to your situation, your marriage certificate with your spouse, especially if they're if you have a dependent that is filing with you. And my recommendations always be very deliberate in your organizational skills, right? When it comes to these documents, don't lose them, right? I've seen clients that will somehow lose their 797A notice of approval. They have to go back to their employer or back to employers and try to get those documents, or they need to raise a FOIA request, which is basically a Freedom of Information Act request to pull your immigration record from the government, which can take up to a month or longer, right? So have all of these documents prepared and ready to go in advance, right? Get your affidavits in advance, get your NABC in advance, collect your criminal records in advance, and have it ready to go in one folder, right? So that when your priority date is current or is going to be current, you can simply hand that off to your attorney, or you'll know where to look if you're trying to file it yourself.
Absolutely. And I hope that it is helping out. All this information has been very, very enlightening so far. And We are already 45 minutes into the show, and it's been superb, And Prashanti was sharing with us earlier that you have gone through this whole process with your spouse. So I hope it's not too personal to ask you if you both faced any complications or problems while you were going through that process.
No, no, not a problem at all. Not necessarily, right? Like when I had filed for her, this was back in like 2017, right? I feel like the processes were much faster then. They were a little bit simpler, much more straightforward. The only thing in a family-based process that's usually different for spouses is that spouses always get a USCIS interview, right? And so for her, it was absolutely, it was fine. We went together, and it all worked out. And also for spouses, you sometimes just get a 2-year green card. So after she got her 2-year green card, you then need to file what's called a 751, which is a petition to remove the conditional residency, so you can get your 10-year green card. So that application took a very long time. And by that time, she was ready to apply for US citizenship. Like that application stayed pending like 3 years.
Mhm.
And so in 2021, I believe it was, we filed her N400, her US citizenship application. And she was also pretty far along with our daughter, so she was like super pregnant at that time. And so we go to, again, we have to go to an interview for the 751 and the N400. And the officer looks at me and she goes, "You're the attorney and the spouse." And I say, "Yeah, I am." And she's like, "You can't come in. I can't let you in." And I was like, "But I've prepared this big folder, this big file. How is she going to carry it?" And she goes, "I'll carry the folder and file for her." And, it's very difficult for them to say, that you don't have a valid relationship at that stage when you've got that big of a file and your wife is that pregnant. And so within 15 minutes, she was out of there. She was like, she barely asked me anything. And she approved my citizenship too.
Lucky
So,
for her. Lucky for
yeah, so like it worked out really well. But, I would say in family based, they always pressure test your relationship at the beginning, even in the middle when you do that 751 petition. They just want to make sure it was entered into in good faith and things of that nature. And that is kind of unlike, the employment-based process, because in the employment-based process, you have folks that end up, like my EB1 folks, no interviews. The guy just got a green card 2 months after filing the 45, right? So it's a little more straightforward for them, I feel, in some ways, than it is for the spouse-based applications.
But seriously, hats off to both of you. So many processes, and you
Yeah,
made it through, and here you are. And there's you, I
yeah,
mean, your whole family out there now. It's so
yeah,
beautiful.
yeah.
Congratulations, even though so late. But let's move on. Let's get back to the topic. And if you could answer, Prashant, what are some typical complications or challenges that applicants might encounter during this I-485 application process? Actually, we've already gone through these, right? Quite a lot. But if you can, yeah.
Yeah, I can maybe, actually, after I answered that question, there are one or two more that kind of came to mind. One of them is the 693 medicals. And this one I can speak through from an example. I had a client who approached me and said, "My wife, she only believes in homeopathic medicine. She does not believe in vaccinations." And I basically told him, USCIS doesn't care, right? Unless you have a very legitimate reason, like a medical reason as to why you can't take a vaccination, or a very strong religious reason as to why you can't take a vaccination, she's going to need to get them, right? So sometimes I've seen clients create a complication by saying, we don't want to take these medications, we don't want to take these vaccinations. And it's like, this isn't about you. This is literally about the population in the US, right? You can't be going around spreading anything, right? And USCIS won't allow that to happen, right? That can be a basis for a denial. And getting a waiver for that is extremely difficult, right? Because they have such a high threshold. So I'd say I have seen that. Another very interesting kind of challenging situation I saw was towards the tail end of 2022. One of my clients, he was the principal applicant, so he's the one that was sponsored by the employer. His application got approved, but his derivative spouse, her application remained pending. And then what happened was the priority dates retrogressed. So this guy got it, but for whatever reason, his wife's application got broken apart from his, was handled by a different officer. And essentially, when the priority dates retrogressed, she was no longer eligible for a green card. And so what we had to do in that situation was he actually had to file a spouse-based application for her. He had to file a family petition despite doing everything right, everything correct, and USCIS making the mistake of breaking apart the applications. So we had to file a spousal petition, an I-130 petition for her. Fortunately, USCIS actually didn't issue an interview in that scenario. They just issued an approval because I think they understood what was going on. And I provided a letter to that effect saying, guys, you broke apart their applications. The husband got it, and he's being forced to file an I-130 now and a new 485 for his wife. So can you just approve it? And so she got the approval as in the family-based process. But that was something that I saw happen one or two more times where the principal applicant got the approval, derivative applicant didn't get the approval, and then was dealing with the retrogression. So that complicated things for them a little bit.
Absolutely. Actually, we covered a lot of complications or things that can happen, mistakes and everything. So, folks out there, you could watch this whole episode once again, after the live session gets over. We will publish this. So, definitely stay tuned, and we'll definitely take up so many questions I can see already. I'm excited to take those questions. But before that, I have a couple more questions, and I think, Prashant, I won't hold you much long because we just
Sure.
have some time left, before we complete an hour. So, if you can, address how can applicants address issues such as gaps in employment history or discrepancies in their documentation when filing the I-485 application?
Yeah, so one thing to keep in mind, right? Employment gaps are totally normal. They can happen because of terminations and layoffs. They can happen because of medical leaves, that sort of thing. So if there are employment gaps, I always recommend submitting a letter of explanation to USCIS in the 485 application. That way it doesn't seem like you're trying to hide anything from them or trying to keep anything away from them, right? In that letter of explanation, you can always indicate, hey, from X date to X date, I didn't have a job because I was laid off. I was in my grace period. During that grace period, I did an H-1B transfer, that sort of thing, right? Or it could be something more serious, right? Where you had to take medical leave for a health condition. That also happens. But you just want to make sure you back it up with the proper paperwork, right? So if it is a medical condition, you're obviously going to have doctor's notes and doctor's letters and medical records. You want to be able to provide those. If there's any discrepancies in documentation, for example, a different name on the passport or the birth certificate and the birth certificate, for example, again, you can submit a letter of explanation kind of explaining the discrepancy. And there's also at the very beginning of the 45 application, they ask you, have you ever used any other names, right? This is an area where you can disclose those different names if there are discrepancies across your applications. But then I would also recommend including that addenda explaining the discrepancy, right? Like at the time of my birth, my parents misspelled it. By the time, I got to school, we corrected it. And on my passport, it's the corrected version, things like that, right? You can even submit an affidavit, from your parent stating that, hey, look, on his birth certificate, we made a mistake, that sort of thing. So there's ways to overcome those discrepancies and employment gaps. Nothing that kills the application or hurts it in any way.
Absolutely. And I think as far as name change is concerned, it's very significant, I think, especially on marriage. Also, you take up the surname changes, the title changes, and of course, we also have superstitious beliefs like the astrologer asks us to change the name and all that. So there's so much happening with the name change. I know a few of them also. Moving on, if you could also, tell us what is the significance of the priority date in context of the I-485 application, and how does it impact the overall process?
Yeah, so the priority date is extremely important, right? Because if the priority date isn't current, you simply can't apply for the 45 application. So as I mentioned before, USCIS has two separate charts. One is the data filing chart, one is the final action date chart. And the data filing chart usually allows you, and it moves along faster than the final action date chart, but it allows you to actually, get your 45 application in. Now, your 45 application won't be approved until the final action date chart has your priority date as current, right? And so, as I mentioned before, right, a lot of people in 2020 that were able to apply as per the data filing charts, and then there was retrogressions across both charts in 2022, as a result of which, they basically had to, just continue, like kind of get back in line. They've got 45 applications pending, but they can't be approved until the priority date is current as per that final action date chart. So the priority date is extremely important because not only does it dictate when you can file the 45 application, but it also dictates when your 45 application is actually going to be approved.
Okay. And I'll take up one more question from my side, and we'll keep the other questions for another episode, Prashant, if that's okay.
Sure.
So, if you can discuss the various types of interviews that applicants might be required to attend as part of the I-485 application process.
Yeah, so for employment-based categories, right, I've typically seen interviews arise when an individual's 45J is being sponsored by a different employer than the one they're working for, right? So this was also covered a little bit in terms of like the complications, challenges that we can sometimes see. So USCIS is kind of always wondering, are you really going to go back to that old employer, right? Especially if they were paying you less, especially if they're in a different city, maybe it's a more junior role, right? And those are typically the circumstances where I've seen in employment-based categories interviews happen. Now, there can be other reasons, right? There could be an immigration violation. You could have a criminal background, that sort of thing, that USCIS wants to learn more about or know more about. But typically, those are the scenarios where I see that USCIS is going to pull somebody in for an interview for the employment-based petitions.
All right. And I think it's time now that we take up some questions also, Prashant, if you're okay to go with it.
Sure.
This one is from N. Malik on Facebook. Can an F1 student apply for H1B visa AOS?
H-1B visa adjustment of status. The question doesn't make
Sorry,
sense.
H1B via AOS.
Okay. No, so the H-1B process is completely separate than an adjustment of status process, right? So H-1B, the application for that is an I-129 petition, and you need an employer to sponsor you for that. So you cannot apply for an H-1B by an adjustment of status application. Two completely separate things.
Okay, and Malik, I hope you got that answered. Now we'll move to China Reddy, and she asked, could you share the link where you are going to post the webinar session? So the link is, the channel on YouTube is Immigration and Jobs Talk Show, where you're already watching, so don't forget to subscribe to us, all you folks out there. But if you want to watch us on on LinkedIn or on Facebook, the handle is the same, so check us out. And now we'll take this one from Sai Kiran, sorry, Iasan. Do we receive a new case number from USCIS for I-485 application, or the I-140 number will be used for tracking?
No, so you get a completely new receipt number. So the I-140 petition has its own receipt number, right? And then when you apply for the 485 application, you should get 3 receipt numbers per applicant, one for the 485, one for the 765, and one for the 131. So you will get in most circumstances, 3 new receipt numbers.
Okay, and now we'll take another one. This one is from Hardeep on YouTube. How does the I-148 application process differ for applicants currently residing in the United States versus those applying from abroad?
Yeah. So the 45 application, I would say, is much more straightforward, right? And there can be a little less waiting time, especially if your priority date's already current. And oftentimes there's no interview, right? Whereas in consular processing, what happens is once your I-140 petition is approved, your application will be sent to the National Visa Center. So the National Visa Center sits in New Hampshire. Once your priority date is current, or maybe it's already current, what they'll do is they will coordinate with the embassy and they'll send you a letter saying, hey, we now need you to go online. You need to fill out a DS-260 application for an immigrant visa. You need to upload civil documents like birth certificate, marriage certificate. You need to upload a police clearance certificate. You need to go do your medical examination. You also need your employer to fill out an affidavit of support, that sort of thing. The consular processing, I feel, and at the end of it, there's also an interview. Absolutely, there's going to be an interview with a consulate officer, right? I feel it has many more steps. There are like 10 steps for consular processing, whereas adjustment of status probably has half the number of steps without the risk of an interview, right? And so that's what I would say is really the major difference is just like the number of steps involved in consular processing, plus that requirement for an interview. Whereas in the adjustment of status, there's a limited number of steps, and more often than not, there's no interview.
Right, right. And all right, so Fawad Ali on YouTube is watching us and he says, thanks to Immigration and Jobs Talk Show and Attorney Dubey for insightful episodes. Your expertise has made a significant impact, providing clarity and guidance on the application process. This truly means a lot. Thank you so much, Fawad Ali. And right, Attorney Dubey, it's so nice when we see.
Yeah, I like getting some kudos. Awesome. Thank you, sir.
Yes, absolutely. Thank you, Fawad. And now I got this one on YouTube from Shinaza. Can you provide insights into the typical timeline for processing an I-148 application?
Yeah, so no timeline is typical, right? They're all actually pretty inconsistent. So I've seen 45 applications that get approved in 2 months, 4 months, 6 months, and a year, right? And where you tend to fall on that timeline, you don't really know. And that's the unfortunate aspect of it. There are steps that you can obviously take. For example, making sure you submit the 693 medicals with your 45 application, making sure you've got all of your paperwork ready and submitted along with the 45 application. So you can intrinsically fast track your process by making sure all of it's submitted, and that you can avoid any sort of RFE situation. But the processing times really are all over the place. Anywhere from 2 months to 12 months is what I've seen.
All right. Thank you so much for taking all those questions up. And I got Bhavini asking some questions and some more questions, but I think we'll save them for the next episode where Prashant Dubey is going to join us again, to talk about the same topic because there's so much more to discuss, right? And what do you have to say, Attorney Prashant Dubey, before winding up today's show so that people can, tune in again in the next episode?
Yeah, no, I mean, thank you to all the viewers who have been sticking with us through this series, right? That really started back in December. But the I-140 process end to end, right, as it concludes with the 45, it is a very robust and lengthy process. So thank you all for for viewing us, asking questions, great questions. Thank you, Nipasa. Thank you, Zayed. Thank you, the wider higher IT team for making all this happen, and hosting us and providing a platform where we can get this sort of information out to people to try and help them.
Absolutely. Even I'm glad we are, helping out so many out there directly, indirectly. And Like I was saying earlier, Bhavini is actually not asking a question, but asking for a pro tip. So we'll keep that for the next episode. And definitely, all you folks out there, thank you for tuning in today. And tune in again on the next episode. We will update you. So for more details and updates, don't forget to subscribe to our channel, Immigration and Jobs Talk Show, here and also on Facebook and on LinkedIn. Immigration and Jobs Talk Show. And thank you so much. If you have any questions, you can mail me also directly at nipa@higheritpeople.com or WhatsApp me on the number 403-335-6444 or visit our website www.higheritpeople.com. And you can also mail Attorney Prashant Dubey directly, with your questions, and he will be very happy to return you with a response. So info at dubeylawoffice.com. That's his mail ID. Definitely mail him. Thank you so much, Attorney Prashant, once again for joining us today.
Thank you.
All right. Have a great day ahead then. All you folks out there, thank you once again for joining. It's Nipasa saying bye-bye for now. And stay tuned to Immigration and Jobs Talk Show because I'm actually going to visit you again at 2 p.m. EST because we are going to have another webinar and we are going to be having Attorney Chan Parvathaneni with us talking about some more interesting things about immigration and jobs. So thank you for tuning in today once again. Bye-bye.